Opportunity to stand here today and just thank everybody for every effort that's being made here. My name is David Lane. I'm an attorney in Denver. I work with Andy McNulty at the law firm of Kilmer, Lane and Newman, and we are proudly representing Jerry in this case. Let me give you a little legalese before we really get going on anything else here. What has happened in the Boise case, before you start kissing up to the Supreme Court of the United States, let me just say, what happened in that case is the Ninth Circuit Court of Appeals, right below the U.S. Supreme Court, which covers Idaho, Washington, Oregon, California, Nevada, ruled the way that Jerry said. You have a constitutional right to live without police harassment. You have a constitutional right to sleep, to eat, to survive. They cannot criminalize poverty. That's what the Ninth Circuit essentially said. The city of Boise asked the U.S. Supreme Court to review the case. And the U.S. Supreme Court took a look at it and said, no, we don't want to review it. Now, there is no precedential value in that, okay? Because a lot of times the U.S. Supreme Court will not review a case until several lower courts around the country have chimed in on the issue. This is the first one. This is the Ninth Circuit. U.S. Supreme Court says, let's see, maybe we've heard about this Denver case cooking up. Maybe what's going to happen in Denver, and the way that this trajectory is going to go in Jerry's case is winner or loser. No matter what, this is what's going to happen. If we win in the county court, the loser will go up to the district court on an appeal. The district court will then write an opinion, and then the next level of review is straight up to the Colorado Supreme Court. And once the Colorado Supreme Court chimes in on Jerry's case, and they will, then the loser will ask the U.S. Supreme Court to review it. The other possible path is a case could get filed by somebody other than Jerry in federal court. And we could ask, and that would end up going up to the 10th Circuit Court of Appeals. That's a whole different case. We would need somebody other than Jerry because the federal courts won't interfere with an ongoing criminal case in the state system. So somebody who is subject to arrest but hasn't been arrested could contact us and we could go to federal court, which might not be a bad idea. Then we get a federal court ruling on it, we get the state courts ruling on it, and the U.S. Supreme Court can then chime in. They'd be more inclined to chime in after a few opinions have been written. So that's all the legalese involved here. But let me just say, the Ninth Circuit opinion is a template for the Denver County Court judge. This judge is, as Jerry pointed out, is taking a long time. It doesn't take a long time to simply say the statute is in fact constitutional and you lose. That doesn't take a lot of time and effort. And the fact that this is taking a lot of time and effort, it's impossible to read tea leaves, and I could be totally wrong, but this judge is writing something that is taking a long time to write. And when you're a Denver County Court judge, and all the powers that be, the cops, the city council, everybody in the community is looking at you. If you're going to throw out a law that was just approved by about 80% of the public in a referendum, you better write something that's pretty damn profound.
Right.
And the Ninth Circuit Court of Appeals gave him a template to do that. So I'm hopeful. The longer he takes in rendering a decision, the more optimistic I get about our chances. But again, it's trying to predict the future, and nobody can do that. But that's where the legal aspects of this are at. In the meantime, anyone who is subject to arrest, anyone who is being harassed, come to my law firm. We are there for you. All right? And we don't charge you guys money to do this stuff. It's who we are and it's how we roll. So, keep up the fight, and thank you all for being here.
Thank you.